PVL3701, Study Unit 4, Original Acquisition of Ownership, Number 1, Introduction. It is customary to distinguish between original and derivative methods of acquiring ownership. Original methods of acquiring ownership are used when there is no cooperation from a predecessor in title. This refers to the person who was owner of the thing before the new owner. In other words, there is no transfer of ownership. This form of acquisition is not limited to things belonging to no one, that is, res nullius. In cases of accession, prescription, and expropriation, the thing is actually owned by another, but no transfer of ownership takes place. Acquisition takes place regardless of the fact that the thing has been held by another. Derivative methods of acquiring ownership occur with the cooperation of a predecessor in title. The right which the transferee obtains is derived from the former owner. This implies that the predecessor in title should himself or herself have been the owner and have been entitled to transfer ownership. This principle is expressed in the maxim, no one can transfer more rights to another person than he has himself. Furthermore, the right is transferred to the new owner with the advantages and disadvantages attached to the right. And then at 1.1, the outline of original methods of acquisition of ownership. You can just study that small table there quickly. Number 2, appropriation, occupation or occupatio. 2.1, definition. Appropriation or occupation, occupatio, is defined as the unilateral taking of physical control of a thing which does not belong to anyone, but which is within the sphere of law, res in commercio, with the intention of becoming its owner. 2.2 Elements. 2.2.1 Control. Physical control is essential for the acquisition of ownership by means of appropriation, occupatio. The acquirer must obtain physical control with the necessary intention, that is, the intention of becoming the owner. One should note that the control need not be lawful. If, for example, a person has no right to hunt, either because he has no license to shoot certain animals or where certain wild animals are protected by legislation, he commits a crime if he shoots such animals, but he nevertheless becomes the owner of the dead animals by means of appropriation. Where wild animals are wounded but actual physical control is not taken, appropriation does not take place. Therefore, if one person wounds a wild animal but another person catches it or discovers the carcass, the latter obtains ownership. We can see this in the case of Rex versus Mwafola 1958. 2.2.2 Thing which does not belong to anyone. Res nullius are things that belong to no one. All creatures that are wild by nature, that is, animals, birds, fish, and insects, either in their natural state, before someone has taken control of them, or when they have reverted to their former wild state, after having been controlled by a person, are regarded as res nullius. Wild animals which have been tamed, domesticated, are an exception. These remain the property of the owner until they lose the habit of returning, when they again become res nullius and capable of being acquired by appropriation. Domestic animals, that is, dogs, cats, parrots, and etc., or wild animals regulated by the Game Theft Act 105 of 1991, are not res nullius and therefore cannot be acquired in ownership by means of appropriation. To determine whether this act is applicable, the following definition must be considered. Game is defined as follows in the Act. Game means all game kept or held for commercial or hunting purposes and includes the meat, skin, carcass, or any portion of the carcass of that game. Products of the sea, that is, seaweed, shells, stones, sand, fish, and shellfish, are in principle open to acquisition by appropriation. Abandoned things, res derelicti, are things which a former owner has abandoned with the intention of ceasing to be their owner. Such things are then res nullius and may become the property of any person taking control of them, as per Rec versus Mills 1990. A lost thing, res deperditiae, is not a res nullius, but remains the property of the owner as long as it is his or her intention to retain ownership. 2.2.3 Thing within sphere of law. Only things that belong to nobody can be acquired in terms of appropriation. Therefore, ownership over body parts, such as a human being or of a corpse, for example, can never be acquired in this way. 2.2.4 Intention of becoming owner. In Underwater Construction and Salvage Co. Proprietary Limited versus Bell 1968, Banks stated that ownership is acquired as soon as there is a seizure with the intention of becoming owner. Although theoretically there should be an intention to acquire ownership, other elements, particularly the element of physical control, can be indications of such intention. Number 3. Accession or accessio. 3.1 Definition. Accession can be defined as an original method of acquiring ownership which takes place when an accessory thing becomes merged with a principal thing, with the result that the two things form one entity. The accessory thing loses its independence and becomes part of the principal thing. The owner of the principal thing is the owner of the composite thing. 3.2 Introduction. It is often stated that the owner of the principal thing automatically becomes the owner of the accessory attached thing, without necessarily even being aware of the joining of the accessory thing to the principal thing. It is, however, incorrect to explain accession in this manner. In reality, the movable accessory thing loses its independence and becomes part of the principal thing. The owner of the accessory thing therefore loses his or her ownership. In this union, the accessory thing stands in a subordinate relationship to the principal thing, in that it loses its independence, while the principal thing retains its independence. It is often difficult to determine which of the prior independent things is the principal and which is the accessory thing. There is no general principle according to which a distinction can be made. In some cases, one considers which object has the greater weight, in others which has the higher value. Traditionally, a decorative thing was seen as being the accessory thing, but if this test is inconclusive, one should consider the weight, size, and use of the thing to determine which is the principal thing. Bear in mind that land is always the principal thing. Strictly speaking, accession is not a mode of acquisition of ownership, but a process whereby the accessory item ceases to exist as an independent thing, and the principal thing is increased or expanded by the attachment. Accession is nevertheless treated as an original mode of acquisition of ownership, since the acquisition of ownership occurs regardless of the cooperation of the former owner. Accession takes a variety of forms, which were traditionally classified as natural, industrial, that means through human activity, or mixed. However, we prefer to classify the various forms in terms of the movable-immovable distinction. 3.3 Accession of immovables to immovables. In discussing the various forms under this section, the following important issue must be borne in mind. A distinction is drawn between situations where the boundary of the land is a natural boundary which is formed by a waterline of a river or the sea, and those where the land has an artificially fixed boundary, even though it is next to water. 3.3.1 Invisible accretion, alluvio. 3.3.1.1 Definition. Invisible accretion can be defined as the gradual and imperceptible addition of land to land through the natural action of water where the natural boundary of the property is a river or the sea. 3.3.1.2 Elements. First, gradual and imperceptible addition. This element is emphasized to distinguish this mode of acquisition from visible accretion. Secondly, through the natural action of water. Invisible accretion usually takes place where silt is washed down gradually as a result of the flow of water. Third, property bounded by a river or the sea. Invisible accretion can only take place where the natural boundary of the property is a river or the sea. Invisible accretion to land bordering a river is more common than alluvio to land adjoining the sea. Therefore, invisible accretion is only possible in the case of an ager non limitatis, that is, a natural boundary which is formed by a waterline of a river or the sea. 3.3.2 Visible accretion. 3.3.2.1 Definition. Visible accretion of vulsio can be defined as an original method of acquiring ownership, which takes place when the extent of land is increased by the sudden addition of land which has by violent natural causes been dislodged elsewhere. 3.3.2.2 Elements. First, sudden addition of land. This refers to a sudden substantial increase in the land. If it takes place gradually, we are dealing with alluvio. Secondly, violent natural causes. A feature which is central to this mode of acquisition of ownership is the violent yet natural dislodgement of land through heavy floods or landslides. Third, dislodged elsewhere. This element indicates that land is dislodged from one owner's land to become attached to another's land. This could be caused by floods or landslides. The test to determine whether the accessory piece of land has become so annexed that a vulsio is said to be complete is whether plants have taken root. The other rules governing alluvio are also applicable here. 3.3.3 Island arising in riverbed. Insula nata in flumine. Flumen. 3.3.3.1 Definition. Insula nata in flumen can be defined as an original method of acquiring ownership where an island is formed in a river by the natural action of water in such a way that the island is divided proportionately and acquired by the riparian owners. 3.3.3.2 Elements. First, an island which is formed. This occurrence is similar to that of alluvio, and similar principles are applicable. Secondly, acquisition by riparian owners. When an island arises in a river and the farms situated alongside the public river are agri non limitati, so that the public river forms the natural boundary of the farms, then the island is divided proportionately among the riparian owners of the farms. This is so because the boundary of the farm in the case of ager non limitatis is presumed to extend to the middle of the public river, as seen in Van Niekerk and Union Government Minister of Lands versus Carter, 1917. Where, on the other hand, there are agri limitati situated along a public river, that is, farms which have artificial boundaries. The island which arises in the public river can be regarded as a res nullius, and it becomes the property of the first occupier. Some authors argue that such an island belongs to the state. And lastly, number 3, proportionate division. In principle, the boundary of the land of a riparian owner, in the case of an ager non limitatis, stretches to the middle of a river. Rights in a newly formed island are acquired by riparian owners on the basis of the proximity of the island to the land on either side of the river. Where the island has been formed in the middle of the river, it is divided by the line running down the middle of the river so that the owners on both sides will each be entitled to half. If the island is closer to one bank, it will be divided in proportion to the distance from the middle of the river. 3.3.4 Dry riverbed. Alveus derelictus. In Roman and Roman Dutch law, the concept of accessio was applied to a dry riverbed which had changed its course. 3.4 Accession of movables to immovables. In the case of accession of movables to land, you must bear in mind that land is always the principal thing. Therefore, the movable thing accedes to the land. 3.4.1 Sowing and planting. Satio et plantatio. Example number 1. S plants potatoes on land he leases from Z. Before he can reap the crop, the term of his lease expires and Z does not renew the lease. The lease contract does not refer to ownership of the crop. Example number 2, based on the facts in Gore N.O. versus Parvatas 1992. S starts a nursery on land that he leases from Z. The plants he puts in include a crop of flowering bulbs. Before he can reap the flowering bulbs, his term of lease expires and Z does not renew the lease. The lease contract does not refer to ownership of the crop. 3.4.1.1 Definition. Sowing and planting can be defined as an original method of acquiring ownership, in terms of which growing things accede to land and become the property of the owner of the land. Accession takes place as soon as the plants take root in the soil. 3.4.1.2 Elements. First, growing things accede to the land. In Roman and Roman Dutch law, the principle was that everything planted on land became part of the land. Omne quod implantator solo cedit. The basis of this principle is that plants, in taking root, derive water and essential nourishment from the soil, as seen in Secretary of Lands versus Jerome 1922. And secondly, become the property of the owner of the land. Where S plant is planted on X and Y's land, it becomes X and Y's property as soon as it takes root. If the plant is removed from the land and at a later stage it remains X and Y's property. The reason that is advanced for the acquisition of ownership of the plants by the landowner is the fact that the plants obtained their nourishment from the soil. It is possible, however, that in certain circumstances, for example, on the grounds of unjust enrichment, S may claim compensation from X and Y. Where there is a specific legal relationship, such as a lease contract between the parties, these principles need not apply. In such a case, the parties may determine the legal position by agreement. Furthermore, special rules apply to plants which a leasee has planted during the concurrency of a lease. Plants which have been planted with the intention of removing them later, or plants which are destined to be removed, do not become subject to the landowner's ownership. 3.4.2 Building. A nidificatio. Example number 1. S builds a house made of corrugated iron for his herdsman. He screws the corrugated iron to the concrete foundation on the farm of his parents, X and Y. After the lease has expired, S wants to remove the house. X warns him that he cannot do that because this would amount to theft. X and Y argue that they have become the owners of the corrugated iron house by accession. Example number 2, based on the facts in McDonald Limited versus Radin N.O. and the Potchefstroom Diaries and Industries Co. Ltd. 1915. S, who purchased Waterford in terms of an installment sale agreement, decides to build a dairy and stables on his farm which still belongs to X and Y. S buys all the equipment to build the dairy from the cooperative C. The cooperative reserves ownership of the equipment until the final installment has been paid. A team of experts working for C installs the dairy under the supervision of S. They build the stable from bricks on a concrete floor. They also install all the pipes and tanks for the proper functioning of the dairy. 2 years after S has started the dairy and before the cooperative has been paid in full, S becomes insolvent and the trustee of his insolvent estate argues that all the structures and equipment are movable assets which form part of the insolvent estate. X and Y claim that as co-owners of the land, they became owners of the structure by means of accession, and the cooperative claims that it remained the owner. Example number 3, based on the facts in Van Weesel versus Van Weesel's trustee, 1924. S leases a portion of X and Y's farm for 30 years, with an option to renew the lease for a further 30 years. He builds houses on the farm for his farm manager and workers. When S leased the farm, a dairy had already been erected on it. Next to the dairy, he erected a house, a windmill, and a stand. From the windmill, a pipe ran to the tank, which stood upon a masonry structure, from which pipes led to the house and the tank. S also erected a cowshed and fences. This was done to facilitate the smooth running of the dairy business. The dairy business ran successfully for 10 years, but then S was declared insolvent, and a trustee was appointed. Example number 4, based on the facts in Standard Vacuum Refining Co. of SA Proprietary Limited versus Durban City Council 1961. Standard Vacuum Refining Company operated an oil refinery on its land situated within the municipal area of the Durban City Council. The latter, when assessing the appellant's land for rating purposes, took into account the value of certain steel tanks which were part of the refinery. These tanks were used for storing unfinished and finished products. The valuators regarded the steel tanks as buildings on the land and therefore part of the immovable property. Standard Vacuum Refining Company objected to the valuation and argued that the tanks were not buildings and therefore not part of the land. They regarded the tanks as movable things. And example number 5, based on the facts in Theatre Investments Proprietary Limited versus the Butcher Brothers Limited, 1978. The original lessors owned certain immovable property situated at the corner of Smith Street and Albany Grove in Durban. A building comprising a theatre, restaurant, and other accommodation, and known as the Playhouse, stands on this property. By notarial agreement of lease entered into on the 6th of December 1926, this property was leased to African Theatres Limited. The original lessors formed the company Butcher Brothers Proprietary Limited and transferred the immovable property to the company in 1930. By a notarial agreement entered into on the 11th of May 1931, Butcher Brothers Proprietary Limited and African Theatres Limited amended the terms of the original lease in certain respects. The following terms of the lease are relevant. Number 1. The lease was for a period of 50 years from the 1st of January 1927 to the 31st December of 1976. Second, the leasee had the right to renew the lease for a further 49 years from the 1st of January 1977 to the 31st December of 2025. Third, the leasee undertook to proceed with the erection of the theatre and other buildings on the said immovable property to a value of not less than £55,000. Fourth, on termination of the lease or any renewal from any cause whatever, all buildings and improvements on the immovable property were to revert to and ipso facto become the absolute property of the lessors without their having to pay or being liable to the lessees for any compensation in respect of the said buildings or improvements. The original lessees duly erected the theatre and other buildings upon the immovable property, and such buildings were named the playhouse. The buildings were solidly constructed and were elaborately finished and ornamented in a manner designed to give the appearance of an early English theatre. The building was large, comprising a theatre with seating on 2 levels, 1,762 seats, a foyer, a gallery, restaurant, and other accommodation. The building was properly equipped for use as a theatre or cinema and restaurant complex and was commissioned for these purposes. The building has been used for the said purposes ever since. Among the equipment installed in the building when it was erected were theatre seats, fitted carpets, lighting and cinema projection equipment, and air conditioning equipment with the necessary ancillary fittings and ducting. The lease was terminated and the lessee claimed that the theatre seats, fitted carpets, lighting and cinema projection equipment, as well as air conditioning equipment with the necessary ancillary fittings and ducting, remained movable, and that as their owner it was entitled to remove them from the theatre. Example number 6, based on the facts in Constance Properties Proprietary Limited versus W.M. Spillhouse in Key, 1996. W.M. Spillhouse sold a number of loose components of an irrigation system to Pumps for Africa, with the explicit reservation of ownership, until the purchase price was fully paid. Before the purchase price was paid, Pumps for Africa installed the irrigation system on a farm belonging to Constance Properties. Constance Properties paid Pumps for Africa, but the latter failed to pay W.M. Spillhouse. W.M. Spillhouse claimed the pumps and the connections in the pump house. It argued that it retained ownership and that the pumps and connections were movable things. 3.4.2.1 Definition. Building can be defined as an original method of acquiring ownership in terms of which a movable thing, that is, an accessory thing, becomes attached to the land, the principal thing, in such a manner that it loses its independence and forms an entity with the land, thereby becoming part of the landowner's land. 3.4.2.2 Introduction. The relevance and importance of this method of acquisition of ownership is evidenced by the considerable number of appeal court decisions. Then you can just study all those cases mentioned there. 3.4.2.3 Elements. First, movables become attached to immovables. The first appeal court decision on the question whether a movable has become permanently attached to an immovable was MacDonald Limited versus Rayden and the Potchefstroom Dairies and Industries Co. Limited, 1915, where Chief Justice Innes stated, "The question whether an article originally movable has become immovable through annexation by human agency to realty is often one of some nicety." It was pointed out in Olivier versus Haarhoff, 1906, each case must depend on its own facts, but the elements to be considered are the nature of the particular article, the degree and manner of its annexation, and the intention of the person annexing it. The court has laid down 3 tests here. These have been applied in a number of cases. However, these tests have not always been applied in the same way, and it is important to identify the differences which have become apparent. The 3 criteria applied by the courts to determine whether a movable thing is attached to an immovable thing by means of a cession in such a fashion that it subsequently becomes part of the immovable thing will now be discussed briefly under the following headings. A. Nature and purpose of attached thing. The nature of the thing must be such that it can indeed be attached permanently to the immovable thing. The purpose of the attached thing must be to benefit the immovable thing indefinitely. Good examples of this are bricks, concrete, and windows, which, owing to their nature and purpose, are suited to form a permanent combination with the land or a building. B. Manner and degree of attachment. The manner and degree of attachment relate to the mode in which the movable thing is attached to the immovable thing. As long as a sufficient linking exists, it does not matter whether this has been brought about by the weight of the thing or by a physical attachment. The attachment may be actually incorporated into the immovable thing, or it may be so secure that separation will cause substantial injury to either the immovable or the movable thing. The key words here are substantial injury. Usually, two tests are applied to determine whether the manner and degree of attachment are such as to constitute a sufficient linking with the immovable thing. First, the manner in which the thing may be detached. If the attached thing can be removed without substantial damage to the attached thing or to the immovable thing, the attached thing does not constitute part of the immovable thing. This is a question of fact, and only ordinary methods and techniques, and not miracles of engineering, are taken into consideration. Secondly, the states of the attached thing after attachment. If the attached thing does not exist independently and is incorporated into the movable thing, losing its own identity, the degree and manner of attachment are regarded as sufficient. In most instances, these two tests are combined. C. Intention of the person annexing it, the annexer, or the intention of the owner of the movable. The content and importance of this criterion have changed since the early decisions. A number of extracts from cases will indicate the trend followed in determining the relevance and application of the intention element as the criterion. Obviously, the intention is determined as it was at the time of the attachment. In the leading case of McDonald Limited versus Radin N.O. and the Potchefstroom Dairies and Industries, 1915, the third criterion was described as the intention of the person annexing it and also the intention with which it was annexed. The judge, however, then added that one can only look at the intention of the owner of the movable. In this particular case, the owner of the movables was also the annexer, but he acted under the supervision of the non-owner, who had bought the movable things on credit and was the holder of the land in terms of an installment sale. The court held that the importance of the first two factors is self-evident from the very nature of the inquiry, but the importance of the intention is for practical purposes greater still, for in many instances it is the determining element. The next decision will come up with guidelines on the issue was Standard Vacuum Refining Co. versus the Durban City Council, 1961. In this case, the annexer was the owner of the land and of the attached movables. Van Vinsen distinguished between an objective intention and a subjective intention in the following statement. Indeed, as I understand the above quoted authorities, it would appear that in each case the object of the inquiry is to ascertain whether the movable has been attached to the land or other immovable with the intention that it should remain permanently attached thereto. In order to ascertain whether such is the intention, regard must be had to the following physical features, viz. The nature of the movable, the method and degree of its attachment to the land and or other immovables, and whether it can be readily removed without injury to itself or to the land or immovable to which it is attached. If the nature of the movable is such that it is readily capable of ascending of acceding to the land or other immovable, and is so securely attached thereto that separation must of necessity involve substantial inquiry, either to the movable or to the land or immovable to which it is attached. Then it must be inferred that the movable was attached with the intention of permanency, and for that reason it must be held to have become and be immovable. If, however, an examination of the physical features produces an equivocal result in the sense that from an examination of such features no inference can be drawn that the attachment was made with the intention of permanency, or otherwise the intention of the annexer may be decisive. A different approach was followed in Theatre Investments Proprietary Limited versus Butcher Brothers, 1978. In the Theatre Investments case, the annexer was the owner of the attached movables, but their lease was made provision for acquisition of ownership of all attachments by the lessor, owner of the land, on termination of the lease. In the Theatre Investment case, Van Vincent remarked at 688 that all the direct and inferential evidence as to the intention would have to be considered together, and that in the light of that existence it would have to be decided on a balance of probabilities whether the annexer intended a permanent attachment. In Constance Properties Proprietary Limited versus W.M. Spillhouse and Key, 1996, the court applied the three requirements as set out in the MacDonald case. Nienaber held that the third requirement was decisive. Although he expressed unease about the correctness of the approach, he applied the intention requirement as referring to the intention of the owner of the movable things that were attached to the land. He held that in the specific circumstances of the case, the subjective intention of the owner of the movables attached thereto was decisive. The ownership of the attached components therefore did not pass to the landowner by accession. The court stated that there is a possibility that in all other circumstances the subjective intention of the owner may not prevail. In each of these cases reflects a different view on the intention criterion. Try to determine the content and importance of the intention element. On this latter point, the question may well be asked whether it is at all meaningful to consider the intention of the owner of the attached thing. Is the question whether a movable thing has become attached to an immovable thing not principally a factual question which has to be answered with reference to the physical features only? This would be an objective approach. Furthermore, one should never lose sight of the fact that we are dealing here with an original method of acquiring ownership, where the intention of the owner of the movable thing should play no role at all. Second, becoming property of owner of land. The landowner becomes the owner of the increased principal thing, since the principle is that the accessory thing as the lesser thing is drawn to the principal thing. What is the position of the owner of the attached accessory thing? Here the following cases can be distinguished. First, a lessee. Before the termination of the lease, the lessee has the right, jus tolendi, to remove improvements other than necessary improvements which can be dismantled without damage to the property. Secondly, bona fide attacher. In Roman and Roman Dutch law, the owner's ownership of the attached materials revived once the building had been demolished, and he or she could then claim the materials back from the owner of the land by means of re vindicatio. This is clearly insufficient protection, and therefore the owner of the material should be treated as a bona fide possessor or holder, whose legal position will be discussed fully below in Study Unit 9, paragraph 2.7, on the protection of possession and holdership. Third, mala fide attacher. The mala fide attacher loses his or her ownership of the materials and cannot claim them from the owner after demolition. The reason being that he or she is deemed to have voluntarily parted with them. He or she can, however, possibly claim on the ground of unjust enrichment as if he or she were in the possession of a mala fide possessor. Number 4. Estoppel. In Constance Properties Proprietary Limited versus W.M. Spillhouse & Key, 1996, the court held that the owner of the movables may be estopped from relying on his or her ownership despite the fact that the movables remained movable in terms of the above criteria. For an application of estoppel in circumstances where the accessory things remain movable, see Concor Holdings Proprietary Limited, TA Concor Technicrete versus Potgieter, 2004. 3.5. Accession of movables to movables. 3.5.1. Definition. Accession of movables to movables can be defined as an original method of acquiring ownership, in terms of which an accessory thing becomes attached to a principal movable in such a way that a single entity is formed and the ownership of the principal thing extends over the accessory thing which has lost its independence. 3.5.2 Elements. First, accessory movable combines with principal movable. The essential criteria for accession in this case are the following. A. The accessory thing and the principal thing should be clearly distinguishable. B. The combination should be difficult to separate. And lastly, it should not amount to manufacture. Specification, paragraph 5 below. Okay. Secondly, formation of single entity. The question of the extent to which the annexure must be final or irreversible is relevant. The examples traditionally given are those of soldering, where dislodgement is possible with no accession taking place, and welding, where the annexure is irreversible and accession takes place. In cases where it is difficult to determine which is the principal thing and which is the accessory thing, the tests mentioned under paragraph 3.2 above are also relevant. 3.5.3 Examples. 3.5.3.1 Painting. Where X paints on Y's canvas, X becomes the owner of the painting, provided the painting is worth more than the canvas. 3.5.3.2 Weaving. Where very valuable thread, for example gold, belonging to X is woven into a cloth belonging to Y, Y becomes the owner of the thread, but under certain circumstances X can claim compensation. 3.5.3.3 Writing. Where X writes on Y's parchment with gold ink, the Romans held that Y was the owner of the document. In Roman Dutch law, when paper had become more readily available, it was held that the author becomes the owner of the paper with the writing on it. Bear in mind that although the person loses ownership of the paper, he or she is not without a remedy. He or she can institute a claim for his or her losses from the new owner. This claim is based on unjustified enrichment. Number 4. Mixing of solids, commixtio, and mingling of fluids, confusio. 4.1 Definition. Mixing and mingling can be defined as an original method of acquiring ownership, in terms of which movable things belonging to different persons are mixed together without the consent of the owners and in such a way that the movables cannot be separated. The mixture becomes the joint property of the former owners in proportion to the value of the things included in the mixture. The mixing together of solid materials, for example grain or feathers, is known as commixtio. The mixing together of liquid materials, for example oil or wine, is known as confusio. 4.2 Elements. First, things are mixed together. Mixing or mingling takes place only where separation of the mixture is impossible, or where it can only be separated with great difficulty. Where separation is possible, each owner retains his or her ownership and can rely on the re vindicatio to reclaim that portion of the mixture which, in discretion of the court, is in proportion to the value of that owner's contribution, as per Andrews versus Rosenbaum and Co. 1908. Where things are mixed, but each thing retains its character, for example, where sheep or cattle are herded together, mixing does not take place, and each owner can claim his or her sheep or cattle with the re vindicatio. Mixing should be clearly distinguished from both accession and manufacturing. In accession, an accessory thing is attached to a principal thing, and in manufacturing, a completely new thing is formed through human intervention. Second, belonging to different owners. This element is self-explanatory. Where the movables that are mixed belong to one owner, acquisition of ownership is not an issue. And third, without the consent of owners. Mixing must take place without the consent of the respective owners. If the owners have agreed that their movable things may be mixed together, they become joint owners of the mixture in proportion to their contributions or as determined by their agreement. In this case, mixing does not take place, but the agreement between the parties creates the co-ownership relationship. Number 5. Manufacture specification or specificatio. Specificatio. 5.1 Definition. Manufacture or specification can be defined as an original method of acquiring ownership in terms of which ownership is acquired by the unauthorized production of a completely new thing, using a thing belonging to another. For example, a person making wine from another person's grapes or oil from another person's olives. 5.2 Elements. First, unauthorized production. The production of the new thing must not be authorized by the owner of the material. Differences of opinion exist as to whether specification is possible, either where the producer was under the impression that the original thing or the materials he or she used belonged to him or her, or where he or she knew that they belonged to another. The acceptable view seems to be that this mode of acquisition of ownership can apply only if the manufacturer was under the impression that the materials belonged to him or her, and he or she produced the thing to benefit him or herself. If the manufacturer was bona fide under the impression that the materials which he or she used belonged to him or her, or if he or she knew that they belonged to someone else, the owner of the material can institute an enrichment action for the value of the material or a claim for damages, in terms of the actio legis ancilia. Secondly, completely new object. Here, a completely new product is manufactured. For example, wine from grapes, or olive oil from olives, clothes from wool, or a ship from wood. By the conjunction of one person's material and the manufacturer's labor, a new thing is formed. Restoration to its former constituent parts should not be possible. In certain examples, it may appear prima facie that the requirement of a new thing has been complied with. For example, articles manufactured from metals. For example, a gold goblet. These can, however, be restored to their original form, and ownership vests in the owner of the material. And third, acquisition of ownership of the thing belonging to another. Where a manufacturer specificator makes a new thing, the former owner loses his or her ownership and the manufacturer becomes the owner of the new thing. He or she is, however, bound on the grounds of unjust enrichment to compensate the owner of the material for its value. Where, however, the new thing can be reduced to the form of the material from which it was made, the owner of the material is the owner of the new thing. For example, if X makes a silver cup from Y silver, then Y is the owner of the cup. If, however, X was bona fide when she made the cup, she is entitled to receive compensation for her labor. Number 6. Acquisition of fruits. 6.1 Definition. Acquisition of fruits is an original method of acquiring ownership, which takes place when a person who is entitled to separate or gather the fruits does so. Before separation, fruits are accessories of the principal thing, and therefore the property of the owner of the principal thing. Upon separation, fruits become independent things which, as such, can form the objects of ownership and become susceptible to acquisition of ownership. 6.2 Elements. First, fruits. Fruits are, firstly, the so-called natural fruits that are the natural products of a thing, such as milk, wool, or the increase of stock. Various states or stages in which natural fruits exist are relevant in the determination of ownership of such things, and the following distinction can be made. A. Hanging fruits. Fructus pendentis. Fruits in existence but still attached to the parent thing. B. Separated fruits. Fructus separati. Fruits which have been separated from the principal thing by a natural process, for example, wind-blown or fallen fruits. Or C. Gathered fruits. Fructus percepti. Fruits which have been separated and gathered or collected. Civil fruits such as rent on immovables, interests on capital, profits from business or other ventures, dividends on shares are also included under fruits, and the same principles apply here. Secondly, separation. Fruits are not independent things until they have been separated. They then form part of the property of the owner of the fruit-bearing thing. By means of separation, they become independent things, which as such form objects of ownership. The separation may be manipulated by human intervention, as in the case of the picking of fruit. It can also take place without human action, as in the case of the birth of farm animals, or where fruit is blown from trees by the wind. Third, acquisition of ownership. After separation, but before the fruits have been gathered, the owner of the principal thing remains the owner of the fruits. There are, however, exceptions to this rule. The following persons acquire ownership of the fruits not at the time of separation, but once they have been gathered. A. Bona fide possessors. In the event of litigation, however, his or her right is suspended from the time of his litis contestatio. B. Leases, and C. Usufructuaries. Number 7. Treasure trove. 7.1. Although treasure finding is sometimes regarded as a form of appropriation, occupatio, this is wrong. The treasure is not necessarily a res nullius, and furthermore, the owner of the land becomes the owner of half of the whole of the treasure through operation of law. He or she is not required to take physical control. 7.2 Definition. Treasure trove can be defined as an original method of acquiring ownership in terms of which hidden treasure, that is, valuable movable corporeal things hidden for so long that it is impossible to determine ownership, is acquired either by the landowner or by him or her and the accidental finder together. Treasure trove can be said to occur when the finder takes control. 7.3 Elements. First, movable, valuable corporeal things. This may include any valuable things such as coins or jewels. Secondly, hidden. The act of finding a thing worthy of the description treasure presupposes difficulty in finding the thing. Third, ownership must be impossible to determine. If it is possible to determine who the owner of the treasure is, ownership of the treasure cannot be established in terms of treasure trove. Fourth, acquired accidentally. Every owner may search for treasure on his or her own land, and if he or she finds any, that person acquires ownership of it. But one may not search for treasure on another person's land without that person's permission. If, however, S chances to find treasure on Z's land without having searched for it, S, as the finder, becomes the owner of half of the treasure, while Z, as the owner of the land, becomes the owner of the other half of the treasure. But if the finder has deliberately searched for treasure on someone else's land without obtaining his permission, the owner of the land becomes the owner of the treasure. There is nothing to prevent an owner of land from giving someone else permission to search for treasure on his land, and if any is found, from keeping it all or an agreed portion of it. Number 8. Expropriation. 8.1. Definition. Expropriation can be defined as an original method of acquiring ownership in terms of which the state acquires ownership of a movable or immovable thing, without the consent of the owner against payment of compensation. Section 25 of the Constitution of the Republic of South Africa 1996 empowers the state to expropriate property for public purposes and against payment of compensation. See the discussion of this section in Study Unit 13, paragraph 2.3. Number 9. Acquisitive prescription. 9.1. Definition. Acquisitive prescription can be defined as an original method of acquiring ownership in terms of which a person who controls or possesses a thing openly and as if he or she were the owner for an uninterrupted period of 30 years becomes its owner. This is termed acquisitive prescription, which is the means whereby real rights in the form of ownership and servitudes may be acquired through the passage of time. 9.2. Introduction. Acquisitive prescription should be contrasted with extinctive prescription. Extinctive prescription is a process whereby both real and personal rights become unenforceable, again through lapse of time and provided that certain requirements are satisfied. Acquisitive and extinctive prescription have this in common. A condition acknowledged in law results from a condition that actually exists. In cases where a bearer of rights neglects to exercise his or her rights and those rights are duly exercised by another, the law should recognize the new condition, provided that some protection of the former bearer of rights is guaranteed. At present, the legal position regarding acquisitive prescription is regulated mainly by legislation. However, some common law sources do not remain relevant and legislation is not the sole source of the law. The applicable statutes are the following. First, the Prescription Act 18 of 1943, and secondly, the Prescription Act 68 of 1969. To 1970, prescription was regulated by the Prescription Act 18 of 1943. The Prescription Act 68 of 1969 applies only to the period of prescription completed after the commencement date of the Act on the 1st of December 1970. Therefore, prescription completed before the 1st of December 1970 will be regulated by the 1943 Act, as will that part of the prescription period occurring before the 1st of December 1970 which was not completed by that date. The period remaining after the 1st of December 1970 will be governed by the 1969 Act, as will any prescriptions commencing after the 1st of December 1970. For this reason, both acts should be examined. 9.3. Requirements. Section 2, subsection 1 of the Prescription Act 18 of 1943 provides that acquisitive prescription is the acquisition of ownership by the possession of another person's movable or immovable property, continuously for 30 years. Nec v. neclam nec precario. Section 1 of the Prescription Act 68 of 1969 reads as follows. A person shall by prescription become the owner of a thing which he has possessed openly and as if he were the owner thereof for an uninterrupted period of 30 years or for a period which together with any periods for which such a thing was so possessed by his predecessors in title constitutes an uninterrupted period of 30 years. 9.4 Elements. First, possession. Possession involves two elements, the physical corpus and the mental animus elements. Physical control depends upon the circumstances and the objective assessment of whether the inference of occupation or control may be drawn, together with the intention of an owner. Animus domini is required. The test which is applied is whether a reasonable person would infer from the circumstances that he or she held the property as if he or she were the owner. Such an inference can be supported by the exercise of certain ownership entitlements and the typical conduct of an owner. Secondly, openly. This requirement in the 1969 Act corresponds with the requirements of not by force, not secretly, not on sufferance, as stated by the 1943 Prescription Act. The nec v qualification gives rise to problems. It is to be doubted whether a person who can retain his or her possession only by means of force ever had sufficient control over the thing. In addition, this requirement makes sense only where short prescription periods are concerned, since the owner might, within the brief period of time, possibly be unable to take action against a person withholding his or her thing from him or her by violent means. Where there is a long prescription period, that is 30 years, it is unlikely that the owner would not be able to enforce his or her rights regarding his or her thing by availing him or herself of legal remedies. This requirement was rightly omitted in the new Act. In terms of the nec clam qualification, that is, not secretly, the possessor must exercise open and visible acts of possession in respect of the thing. This corresponds with the openly as if owner requirements of the 1969 Act. In addition to being peaceful and open, the 1943 Act required that possession should be nec precario, not on sufferance. This terminology caused difficulties. In Malan versus Naby Gelegen Estates, 1946, it was held that nec precario does not mean without permission or with consent in the wide sense, but not by virtue of a precarious consent, or in other words, not by virtue of a revocable permission, or not on sufferance. Chief Justice Watermeyer continued as follows. It should be pointed out that the mere occupation of property nec v nec clam nec precario for a period of 30 years does not necessarily vest in the occupier a prescriptive title to the ownership of that property. In order to create a prescriptive title, such occupation must be user adverse to the true owner. This adverse user is not mentioned in the 1943 Act, and some authors have interpreted it as an additional requirement. However, it would seem that adverse user and nec precario refer to the same requirement. The intention of these three concepts has been problematic. The interpretation of these three concepts has been problematic. It can be argued that the nec precario and nec clam requirements are adequately covered by the requirement of possession. The acquirer must possess animo domini, with the intention of an owner. In view of this argument, there is no practical distinction between the old and new prescription acts. Thirdly, as if he or she were the owner. This requirement refers to the animus domini of the possessor, as borne out in his or her external conduct. Fourthly, for an uninterrupted period of 30 years. A period of predecessors in title added. In common law, a possessor who claims that he or she has become the owner of a thing through prescription is entitled to calculate the periods of possession of his or her predecessors in the title, together with his own, in order to comply with the requirements of a period of 30 years. This was known as an adding of time periods, coniuntio temporum, as seen in Stevenson and Lamsley 1948. For example, X has possessed a thing for 10 years, but Y, from whom X obtained it, possessed it for 20 years. X may then add his period of possession to Y's and claim that he has become the owner of the thing by prescription. Section 1 of the new Act confirms the common law position. B. Absolute continuity not required. In Morkel's Transport versus Melrose Foods 1972, it was held that it is not necessary that every part of the land be occupied or used, nor that possession be absolutely continuous. In practice, all that is required is possession of a sufficient degree to justify the conclusion that the exercise of a right of ownership was continuous. The onus would then be on the defendant to establish non-continuity in the sense required. And C. Disturbance of continuity. Continuity of possession may be disturbed by interruption or suspension. A. Interruption. In the case of interruption, the period of prescription which has already run is terminated, and the period of prescription must begin to run anew, de novo. Interruption can occur in two forms. First, natural interruption, and second, judicial interruption. First, natural interruption. At common law, natural interruption occurred when the acquirer lost possession of the thing. He or she could have lost possession by relinquishing it voluntarily. It could have been forcibly taken from him or her, either by the owner or by an outsider. He or she could have been prevented from further exercising control over the thing by an act of God or vis minor. For example, wartime conditions. Be that as it may, for interruption, actual loss of possession is required. Mere protest on the part of the owner is not sufficient. The 1943 Act did not alter this legal position in any way. In the 1969 Act, however, the legislature introduced a change regarding natural interruption. Section 2 of the 1969 Prescription Act provides that the running of prescriptions shall not be interpreted by involuntary loss of possession if possession is regained at any time by means of legal proceedings instituted within 6 months after such loss for the purpose of regaining possession, or if possession is lawfully regained in any other way within 1 year after loss. Examples of cases where Section 2 is applicable are those in which possession is regained. First, within 6 months by means of a spoliation order. Secondly, within 12 months if the thing is returned to him or her by the thief or the police. Or thirdly, if wartime conditions interrupted his or her possession, and such conditions improved to such an extent that he or she can regain possession of the thing. In these situations, prescription continues to run. Prescription can only be interrupted and therefore terminated by, first, through voluntary loss of possession. Secondly, if the possessor waits too long before taking legal steps to regain his or her possession. And lastly, if the situation involving an act of God prevents the possessor from regaining possession within 12 months. Secondly, judicial civil interruption. At common law, prescription is interrupted by the serving of any process. Process includes any document by means of which legal proceedings are commenced, for example, a petition, summons, notice of motion, ordinancy, or etc. The process must clearly set out the claim to ownership and who the owner of the thing is. A mere claim for rent or compensation due to unlawful possession is insufficient. Section 4 of the 1969 Prescription Act provides: first, the running of prescription shall be interrupted by the service of the possessor of any process whereby any person claims ownership in that thing. Secondly, any interruption in terms of subsection 1 shall lapse, and the running of prescription shall not be deemed to have been interrupted if the person claiming ownership does not successfully prosecute his claim to final judgment, or if he abandons the judgment or the judgment is set aside. And lastly, if the running of prescription is interrupted as contemplated in subsection 1, a new period of prescription shall commence to run, if at all, only on the day on which final judgment is given. The mere service of process does not permanently interrupt the course of prescription. Interruption occurs only if the person who lays claim to ownership succeeds in carrying his or her claim to the final judgment. The serving of process has the effect of temporarily interrupting the course of prescription, but if the plaintiff abandons his or her claim, or if judgment or even absolution from the instance is given against him or her, the temporary interruption lapses with retrospective effect. Conversely, if the plaintiff carries his or her action through successfully to final judgment, prescription is interrupted and has to start running anew, de novo. B. Suspension. Suspension is the temporary suspension of a period of prescription. Here the period which has already run does not lapse, but the course is suspended and can recommence at a later date. Suspension of the prescription period takes place in favor of a number of persons whom the law wants to protect by not allowing prescription to run against them. They may be incompetent to enforce their rights, or other reasons may prevent them from enforcing their rights. The underlying reason for suspension is the fact that these persons cannot assert their rights. The principle is formulated as follows: prescription does not run against persons who cannot institute action. Contra non valentem agere non curat prescriptio. These categories of persons are: first, minors; secondly, insane persons; thirdly, married women with retention of the husband's marital power, although the marital power was completely abolished in Section 29 of the General Law 4th Amendment Act 132 of 1993, they should not be interpreted to the detriment of women against whom prescription was running during the period when they were still subject to the marital power of their husbands. Fourth, persons absent from the country because of war, or those who are employed by the state. And fifth, fiduciaries. In the case where a fiduciarius has alienated fiduciary goods without the power to alienate, until such time as the fiduciary goods are distributed. The 1943 Act does not provide for the protection of a disadvantaged owner from acquisitive prescription running against him or her. Consequently, the common law is applicable to any period of prescription that ran before the 30th of November 1970. The 1969 Act differs from the previous Act and provides in Section 3 that where an impediment, see categories of persons who are unable to enforce their rights, exists, and the period of prescription would, but for the provision of this subsection, be completed before or on or within 3 years after the day on which the relevant impediment has ceased to exist, the period of prescription will not be completed before the expiration of a period of 3 years after the day on which the impediment ceased to exist. The practical effect is that the running of prescription is not suspended during the existence of the impediment, for example, minority, but the completion of prescription is merely postponed for 3 years after the impediment has disappeared. This postponement occurs only if prescription would have been completed before or on or within 3 years after the impediment has ceased to exist. In other words, an impediment which falls away more than 3 years prior to the expiry of the 30-year term of prescription in no way affects the completion or course of prescription.